Hello friends, welcome to IS Point. Today is June 30 and we are going to see the articles of the Hindu. And before going in for articles, I request you guys to please review and comment on my video so that I could improve myself and make some awesome videos for you which could benefit you. So coming to the first article, a welcome scale. This article is all about the recent cabinet approval of disinvestment in Air India. See, the disinvestment happened because the state-owned airlines Air India has a depth of over 52,000 crores, which is twice than the value of the aircraft. This means that even if the aircraft sells all its assets, it will not be able to wipe up its debt. And the recent Niti Aayog suggestion to write off 50% liabilities through privatization and advocating for privatization made the government to go for this bold step. And the article tries to say that it was a long-standing reform, actions needed to be taken, and it is taken right now. And it also says that the government was not able to bring out huge amount of money to help the airline who is in the burden of debt, and the market is also dominated by the private players who constitute or who dominate market up to 85 percentage. So it leaves no room for the airlines to overcome its debt. And it also says that Air India being the total government funded agency, so it is ultimately the government who has to fund. So instead of funding these debt, they can use the fund for important socio and infrastructural projects. And the article also tries to brings in few facts. It says that in the year 2012 there was a debt for the airlines which was 30,000, and now the debt has been reached to 50,000 crores in books. So it is ultimately the responsibility of the government to stop indulging losses, as the money which is paid is tax payers money. So while saying all this, the article says that it is not clear up to now that whether the disinvestment will be full or partial. And a ministerial panel has been set up under Arun Jaitley, who will look into this disinvestment proceed and will decide up to what percentage will be the disinvestment. While saying all this, the article also says that a bold step has been taken in the form of a decision by the government, and the government should go for the sale of its entire stake. While saying all this, it also says that the aim of the disinvestment should be that best price should be provided for the airlines, and the bidding should be in a free and transparent manner. There are few serious players who are ready to make bid, and Indigo showing their willingness to make the bid is an welcome move. While saying all this, the article says that this move will be an initial step to check others PSU disinvestment, and it could act as a preview of government actions against the debt burdening PSU. So that's it from this article. We'll move to the next article. So coming on to the next article, the plain truth. See, before going into this article, I'll just give you the brief background. See, the background is all that it is a demand of Madhesi's people for fair representation and federalism in the Nepal constitution. I'll give you a brief background first. See, I've given you a map here. While the dark green area is a Terai region where the Madhesis peoples are populated. Okay, fine. In the right hand side, I have given you a map where the proposed federal regions and districts according to the Nepal constitution is shown. You can see that the blue lines, these blue lines are the constituencies which have been divided vertically. But you can see here in the first map, the Madhesis people, they have been populated horizontally. So if at all, in case, according to the Nepal constitution, if the constituencies have been divided horizontally, then Madhesis would have got popular representation. So they could have been in majority in any such constituencies. But because the constituencies have been divided vertically, they are not in majority. So this is the basic issue. Now, what the Madhesis people did is they started the political movement in Terai region, and they have been demanding for the federalism and the fair representation in the Nepal constitutions. So what the Nepal constitution is on the basis of geographical area, and the Madhesis people, what they want is population representation. So the demands has been unsettled and unmet till now. Okay, fine. And now coming on to the article. So this article tries to say that recently there was an local election which held in Nepal where the Communist Party came into power. See, Communist Party came into power because of the Pahadis. See, Pahadis are the people who live in the hill districts in Nepal. Fine. So these Pahadis are in majority in Nepal. So these Bahadis community and the Communist Party have been opposing uh, Madhesi's demands. So that's why they came into power. And the articles also tries to brings in a few backgrounds. It says that the struggle for the uh, fair representation have been going on from the year 2006, and they have been engaged in many economic blockage, and still the issues have been unsettled. So the disputes have been unresolved now. So what the article tries to say is this, it is the basic ideology of the Communist Party, that is the unified Marxist Leninist, that seeks that Madhesi should not be in majority. So it is because of their main agenda the Madhesis are not in majority right now. And while saying all these facts, the article tries to say is that the Madhesis' faith in democracy must be secured with proper amendments, and Madhesis should be given their demands, and their demands should be met. So that's it from this article. We'll move on to the next article. So coming on to the next article, making the house rules. See, this article is all about the privileges and the defamation case. It tries to correlate the privileges with respect to the fundamental rights. I've given you the background of the fundamental rights of freedom of speech and expression in the background in the before videos. So I've given you the link in the description. You can just look at the background first, and let's move on to the article. See, this article tries to explain the two provisions of the Constitution. One is Article 105 and Article 104 with respect to the center and state legislature, respectively. See, the Article 105 and 104 are the privileges which are presented to them. So the privileges, according to the Constitution, is it's provide freedom of speech in Parliament, which is subject to other provisions of the Constitutions and standing order of the House. It also provides immunity from all speeches and votes in the Parliament from judicial scrutiny. So these are the privileges which are presented to them. And the original Constitution also made a provision that one has to codify the privileges, and until then, it is the British Parliament Convention which will be followed in the Parliament. So until now, it is the British Parliament conventions of privileges has been followed by the Indian Parliament. So while giving in all the facts, the article also tries to say that there are many evidences of the breach of privileges, while many incidents has been seen. For instance, it tries to brings out an example from the Tamil Nadu Legislative Assembly sentenced the publisher and two senior journalists of the Hindu and the editor of Murasoli to imprisonment for contempt of the privileges. And the recent Karnataka State Legislative Assembly passing an order to sentence two editors to jail is an example of the breach of privileges. So this article tries to brings in and says there are many unsettled questions in the provisions of the privileges. It says that what privileges should be protected is unknown, and it tries to correlate privileges with the fundamental rights. It says that the privileges have been provided for the MLA, but at the same time, it is the fundamental rights which has been provided for the public. So this breach of privileges with respect to the fundamental rights is clearly uncodified, and it's clearly not seen, and there needs to be a separate codification. And can the breach of privileges can sentence someone to the jail? It's also another question. And the article also tries to say this: there are two privileges which is given in the Constitution, and rest what are the privileges and where is the codification? So this article tries to puts in some unsettled question, and again bringing in the fact that it says that the framers of the Constitution envisaged for the codification, but still no steps have been taken for codification, and we have been following the British House of Commons till now. So while giving in all the facts, the article tries to bring down the solution. The solution which the article tries to say is that one should pass law to codify the privileges. The Parliament should pass law to codify the privileges, so that a clear-cut definition of the privileges can be brought out, and these sort of conflicts can be avoided. And the article also tries to say that the time has come for the judiciary to intervene and find the right balance between the fundamental rights and the privileges. So that's it from this article. We'll move on to the next article. So coming on to the next article. See, this article in the opinion page is talking about the sedition law, whether the sedition law should be scrapped. So before going into this article, I'll just give you a brief background of what the sedition law is. See, the original constitution does not define the sedition law. It is under the section 124 A of the Indian Penal Code, which defines sedition. I have given you the definition of sedition in the screen, where you can go through this, but I'll just give you the crux of that. See, it is something which brings disaffection to the government. Fine. It is something which brings disaffection to the government. So this is what the sedition means. So it may be in the any format. So the origin of sedition can be linked with the Wahhabi movement. Wahhabi movement happens to be an Islamic revivalist movement. So the British termed the Wahhabis to be traitors, and they brought in this sedition law in the year 1870s to curb the Wahhabis. And there are many incidents of this sedition law being used with respect to the Indian freedom movement. You can see that Bala Gangadhar Tilak was sentenced to jail for urging the Chapekas brothers. So it was under the sedition law he was sentenced to jail. And also after independence, there are many incidents of this sedition law being used. For instance, in the year 2012, our famous cartoonist Asim Trivedi has been sentenced to jail for the under the sedition law. So this sedition law has been with respect to several criticism and discussion whether it should be scrapped or not, whether we should have this sedition law or not. So this article is very important with respect to the mains point of view. So I'll will go into the analysis of this article now. So now coming to the analysis of the article, here the three views are present with respect to the sedition law. While the leftists argue that this law is used as a power to muscle down the freedom of expression, and it is used as a tool to curb the freedom of the expression, and exercising this they can brand one as an anti-nationalist. They bring out an example of an JNU, saying that the people of JNU has been sentenced to jail with the usage of the sedition law, and no charge sheet has been filed against them. While the leftists also argue that the conviction rate with respect to the sedition law is also very very few, and it says that it refers to a no question culture where people cannot demand their rights, and if at all people use their rights, sedition law can be forced. And as they say, it is a force to curb a right protest, and the police generally misuse this sedition law. And it also tries to bring in few examples such as Kudamkulam issue, where people protesting against a nuclear power plant has been termed as seditious, and Adivasis rights in Jharkhand has been termed as seditious. So these sort of views has been placed by the leftist, while the rightist view that it is used as a tool to ensure the peace and security of a nation. And generally what the writers try to argue is that any acts which is immoral and illegal should be punished, and this seditious law tries to brings in public peace, and it tries to brings in certain discipline with respect to the freedom of speech and expression. So maintaining and discipline is an good with respect to the right, and it tries to brings in a few examples. The examples which it states it's separate state of Kashmir, that is the demand for a separate state of Kashmir is seditious, while violent revolution can be termed as a seditious. So it is used as a right tool in order to curb the violent protest, which can be used in public peace, which brings out the public peace. While the central view is that they there is a need to reform the sedition law, and they say that this sedition law is used as an last resort. See, it tries to say that mere criticism of the government in the form of freedom of speech and expression is not seditious, but anything which is involving the sovereignty and the integrity of the state can be termed as seditious. But it also tries to say that there is a need for the Supreme Court to revisit its own judgment with respect to the seditious laws. So there is a need for reform with respect to the seditious laws because of the happening misplaces and the misuses of the seditious law. And while saying all this, the central gives example that see, the Naga agitation for their own rights and no Hindi Day in Karnataka is not seditious, while a separate state of Kashmir and Afzal Guru attacking the democracy of an India can be termed as an seditious. So So there is a need for seditious law, but in an reformed manner. So while saying all this, I'll just add one more point to this. That is a famous case with respect to the sedition law. That that is Kedarnath case versus state of Bihar. It is a famous judgment with respect to the sedition law, where the Supreme Court held that it would retain the sedition law in order to bring in peace and prosperity to the people, and to regulate the freedom of speech and expression in a certain way. So because UPSC asks questions in mains with respect to the cases, so this Kedarnath Singh versus state of Bihar is an important case with respect to the sedition law. So that's it for today, guys. Thank you for watching.